Good morning, everyone. I'm Paul Marcus. I'm on the faculty of the College of William & Mary. I usually don't speak with such a frog in my voice, so I apologize for that, just getting over a bug here. For the next couple of days, I remain president of the Association of American Law Schools, and it's my privilege to welcome today law school deans, law school faculty, and administrators from across the country and the world. We have quite a number of people visiting us from overseas to the opening plenary session of the Association of American Law Schools. This year, for the third time, we've also invited leaders of the bench and bar to be with us, and we think this presents a real opportunity for everyone concerned. Members of our community, lawyers and judges, it's a real pleasure to have you with us. It's been a real honor to work this year with the executive committee, which is the governing board, which you folks actually elected, the governing board of the AALS, and they've worked with real dedication and imagination to make this year happen, a very extraordinary year. I see several members of the executive committee here. For those who have served currently or in the past on the executive committee, I would ask that you please rise, and we acknowledge you. Now, don't be shy. I know there are a few of you there. Thank you. Several members of the executive committee are finishing their terms this year. Darby Dickerson from John Marshall Law School, Abi Sofer from the University of Hawaii, and Kelly Testi, who was at the University of Washington, now heads up LSAC. As I'm sure you know, it takes literally a huge staff to accomplish this meeting. Unfortunately, the ALS does not have a huge staff, so we have a large number of volunteers. Truly hundreds and hundreds of faculty colleagues from across the country helped to put this on. We have program committees, we have section chiefs, we have all sorts of folks who've done all the planning for the coming week. Finally, let me give thanks to the extraordinary staff of the ALS. It is really a lean staff, that's for sure. Our executive director is Judy Areen, who guides us very well. The meeting has been particularly focused on with the work of Tracy Thomas and Mary Cullen, and they've done an extraordinary job. Mary and Tracy, where are you here? They are in the very back there. Thank you so much for all that you do. Good teaching matters a lot to all of us. It matters to our students, it matters to their future clients. And recognition of excellence in teaching is one of the ways that we as law professors reinforce this important academic value. Teachers were recognized by their law schools during the 2016-17 year for outstanding performance in the classroom, and they're listed in the programs that you all received. If we have any of those teachers of the year with us today, please rise. Any of the teachers of the year here with us? Congratulations, that is what we do best. Well, today we gather to talk about access to justice, a concept which is at the core of our constitutional society. Supreme Court Justice Lewis Powell once wrote, "Equal justice under law is not merely a caption on the facade of the Supreme Court building, it is perhaps the most inspiring ideal of our society." As Ida wrote in our program brochure, these are difficult times in the United States for poor people in need of vital legal assistance. Criminal defense lawyers are overwhelmed with enormous caseloads. Defendants can be afforded little time to consult with their attorneys. The problems on the civil side are just as severe. Thousands of our fellow citizens are unable to receive help with legal problems because of routinely underfunded legal aid programs. It is my distinct pleasure this morning to welcome 4 nationally prominent and thoughtful individuals who will discuss with us the problems they see with access to justice. They will, in addition, and this is really the case, right, folks, propose solutions to some of those problems in providing the kind of legal assistance that our nation aspires to. Our panel is, alphabetically, Cara Drinan. She's a professor of law at the Catholic University Columbus School of Law, visiting this year at the George Washington University. Next to her is Bernard Goodwyn, who's been a justice of the Virginia Supreme Court for the past decade. Before that, he served as trial judge for more than 10 years. At the end is Alex Gulotta, who recently stepped down as executive director of Bay Area Legal Aid in Oakland. And right in the middle is Martha Minow, who just finished her term as Dean of the Harvard Law School and is Vice Chair of the Legal Services Corporation of the United States. Now, our panel discussion today is going to be a little bit unusual. Witness how we are seated here. There's no long table, there's no podium, there's no formal timing set in here. We're really hoping to engage one another and you as well. Secondly, it's unusual because I'm asking each one to speak very briefly, really 10 to 15 minutes at most, discussing just two broad questions, and I'm going to address this to each of them. Question number one, we have heard much about access to justice. What is the situation today as to the civil or criminal justice in the United States? And two, what could or should we be doing to improve that situation? Now, that first part of the program will be about 1/2 of our time allotment. The second part will be more of a give and take. I think as you came in, you got a little 3x5 card there. If you have a question you'd like to address to the panel members, whether individual members or the panel itself, just write it down legibly, if you would please. And about midway through, I'm going to ask our student helpers to go by and pick them up. And then we have two very able colleagues here who will sort through them and get me some good questions to ask in the second part. They are Aaron Tang from the University of California, Davis, and Terry Pullman from the University of Nevada, Las Vegas. Thank you, Terry. Thank you, Aaron, for doing that. And then we'll be off and running. Now, without any further time spent on introductory matters, let's get right to it, shall we? Dean Minow, what is the civil situation as to civil justice today in the United States, and what should we be doing to improve that?
Well, thank you, and thank you, Paul, for making this topic the theme of this conference and infusing the questions that you're posing to us throughout the entire time that we're here together. I want to add a third question, and I promise I will try to answer your first two, but the third question is, why is it so hard to get public attention and commitment to this cause? So I'm just going to tell a couple stories, and because I have a hypothesis that people are more moved by stories than they are by statistics. But I'll give you some statistics, and I'll even give you some cost-benefit analysis, and I'll even give you some normative principled arguments, but I have not found any of these getting the kind of purchase that I think they should. So that's why I want to put the third question to this group. So story number one, Garrett and David were born prematurely to a homeless mother who used methamphetamines during pregnancy. The two children experienced severe developmental delays in motor coordination and speech. And their adoptive parents tried, without success, to get them early intervention services. And without those services, they faced really a dire future. A legal aid organization successfully secured for them speech, physical, and occupational therapies. They are improving so speedily that they are enrolled in kindergarten, regular kindergarten right now. A military veteran with serious mental health issues applied for disability benefits for over 10 years, repeatedly denied. Like many veterans, she didn't understand the process, which actually is quite arcane, and the appeals situation. Finally, a legal services attorney obtained the veteran's records, which showed that the military doctors had resisted any kind of treatment for that over a decade. And the inquiry resulted in retroactive disability compensation award dating back to the initial application of the mid-1990s and payments totaling almost $250,000. And just one more. In New Jersey, a 16-year-old named Joseph lived with his grandmother in subsidized housing. His grandmother passed away. The voucher for the housing became invalid. He was going to be moved who knows where, foster care or something. Northeast New Jersey Legal Services stepped in and brought housing and family law experts together and succeeded in transferring the subsidized voucher to an aunt, Joseph's aunt Linda, who moved into the apartment, allowing him to continue living there and to continue at his school. These are success stories. I'm moved by them. Are you moved by them? They seem powerful to me. And they show how legal help can make a transformative difference in the lives of people who face crises in the most fundamental aspects of their lives. Housing, food, physical safety, education, benefits that they are entitled to. The problem is, at least on the civil side, the law does not enforce itself. The law needs someone to come in and help. And when people get help, when people are able to access the legal system, it can be not only transformative for them, but also for their own communities. The flip side, of course, is when that doesn't happen. And we actually are now facing, the word is so overused, a crisis. But let me just explain why I mean that. Despite the claim of equal justice under law, right there chiseled in the Supreme Court edifice, nearly 1 in 5 Americans now qualify for federally supported civil legal assistance because they live at or below 125% of the poverty level. By a conservative estimate, a study conducted by NORC at the University of Chicago, fewer than 20% of the legal problems experienced by low-income individuals receive legal representation. One legal services office I visited closes their intake after 2 days each month because they're already full. And during the crisis since 2008 that has been experienced across the country, what has been the response? The response has been further cuts in the funding that's available for legal services. In the most recent continuing resolution in the Congress, there is money for an emergency relief. And guess what? Legal services is one of the frontline services during the emergencies of the hurricanes and the fires and the disasters. But at the same time, Mick Mulvaney, who is the head of the Office of Management and the Budget, is spearheading an initiative to defund the Legal Services Corporation in the United States, 100%, to eliminate the funding. So there's ships crossing in the night. Yes, we need emergency legal services, but let's close down the entire organization. I am honored to serve on the board of the Legal Services Corporation. My colleague, Gloria Valencia Weber, is here and has done outstanding work there, including outreach to American Indian communities where the devastation continues. I don't think it's worse since the 2008 crisis because it was so bad to begin with. And the dependence on federal funding is, of course, greatest in the poorest states. I guess I could say greatest in the red states, but I'm not political here. Nationally, 75% of funding for legal aid comes from the federal sources. All the sources, though, are strained. One of the sources I think we all know here is IOLTA, the interest on lawyers' trust funds accounts. The interest level has been at record lows, slight increase recently, but still, it's not going to make up the difference sufficiently for what have been the drop-off in the last 8 years. Legal services programs have laid off between 15 and 20% of their lawyers over the last 8 years, and similar numbers of their non-lawyer assistants and staff. And this is at a time of crisis. And the 60% of trial judges who were recently surveyed reported that unrepresented litigants fail to present necessary evidence. Duh. They commit procedural errors. Duh. They're ineffective at cross-examination. Who is surprised at that? And they fail to present enforceable orders to the court. One judge describes the unrepresented individuals in court as like a car that's broken down in the highway. And it actually is not just a disaster for that person, it's a disaster for the system in general. Okay, I've given you some stories, I've given you some statistics. I don't know, let's try a little cost-benefit analysis. Compared with a control group, tenants who are given lawyers, compared with tenants who are not given lawyers, on average, are twice as successful in retaining possession of their housing and almost 5 times as successful in getting adjustments or waivers of their rent. I don't know, cost benefit, that seems like it's effective because otherwise the spiral that occurs with evictions is homelessness and further burdens. Another way to talk about the cost-benefit analysis is to talk about how each dollar spent on civil legal assistance actually returns between $3 and $7 in each state. And why is that? Again, it's estimates in terms of savings in emergency care and also, frankly, securing benefits that are due to the individuals. In Maine, for example, 2015, $2.6 million saved because of legal services. Why? Because states' emergency and homeless shelters were able to save the expenditures they otherwise would have had to make. So, okay, cost-benefit analysis, are you moved? I am, but it doesn't seem to make much of a difference in national or even state-level discussions. I think it's not bad to talk about doing the right thing, to talk about what equal justice for all, to talk about the Pledge of Allegiance, a nation that promises justice for all. These are idealistic statements, but I think it's not bad also to talk about how it's the obligation that we all have to recognize it could be us. It could be us on the street. It could be us facing domestic violence. And my own experience in helping societies recover from violent conflict in the former Yugoslavia, Rwanda, underscores the centrality of an effective, respected legal system. If you don't have that, you don't have anything. You can't actually even secure regular distribution of emergency aid, which we're now experiencing in this country, if you don't have respect for the legal system. And my old boss, Justice Thurgood Marshall, once said, in the recognizing the humanity of our fellow beings, we pay ourselves the highest tribute. And I guess that's what I think is the most motivating. I'll just close by saying I've speculated that there are two reasons why we are not able to secure sufficient public attention to these issues. The first is, let's face it, people hate lawyers and they hate the legal system. And, you know, we can talk more about that, but I can tell you the jokes that underscore that, but I think it's true. And so the idea of giving money to lawyers or to legal aid is not high on people's wish list. But a second reason, I think, that may be a little bit more complicated, some people might call it compassion fatigue or just hopelessness, that it's kind of overwhelming. And I think especially at this moment in the country, there's a long list of things to be concerned about. And this doesn't look like it's high on the list, even for people who are motivated to do something to better their communities. And I think that what's somehow needed is a way to explain the multiplying effect of investment in legal services, not just cost benefit, not just because it does the right thing, but because it also staves off the danger of a destruction of legal norms, a destruction of respect for the legal system. If we don't have that, there's really not much hope for much else. So I do promise to give you some sense of promising alternatives and not to be so depressing, but I yield my time to my distinguished colleagues.
Boy, we're poised here. Alex, let me turn to you.
All right, good morning. How's everybody feeling? Looking a little depressed, and I'll pile on a little bit.
Understand, Alex, that a lot of these folks are here from the East Coast. So actually,
it's really
pretty good outside.
So I've been a legal aid lawyer for about 33 years. I ran the legal aid program in Charlottesville, Virginia for 20 years. I was at Bay Area Legal Aid for 4 years. When I was in Charlottesville, I taught clinical programs in employment law and mental health law, and so I have a little bit of a sense of what your world is like, and I think you have a little bit of a sense of what my world is like. I'm currently doing consulting in the Access to Justice community. I'm also the immediate past chair of the National Legal Aid and Defender Association, and in the decade or more that I've been involved in NLADA board politics and working through sort of the systems, I've really gained an insight into the criminal justice system that I probably didn't have as just a civil legal aid lawyer, that I think is important to look for the intersections. And I'm going to talk a little bit about that. In preparing for this today, I think the original conception is that this would be some sort of uplifting discussion about the current state of access to justice, or there was at least some discussion about that. And one of your colleagues who's unable to be here sent what I would characterize in Harry Potter terms a screamer of an email saying, that's like the whole wrong approach, right? What you need to do is you need to use shock, you need to talk about a national disgrace. You need to focus on the fact that under the World Justice Project's Rule of Law Index, the United States ranks 94th out of 113 assessed countries in access to justice. He says it's not a story of success. Quote, it's a depressing tale of 240 years of failures to deliver on our promises. All right, that's pretty condemning. And I'm not quite that negative. I have more hope than that, or I probably wouldn't have been able to continue to do this for so long. But at a basic level, I think your colleague is right, okay? Because what we want is we want a system for access to equal justice. That's what we want, right? We want a system for access to equal justice. And what we have are 1,000 points or maybe 10,000 points of random disorganized light. Okay, that's what we have. We didn't create a system for access to civil justice. We created hundreds of organizations that are competing with each other for funding, that have separate boards of directors, that each have different criteria for who qualifies for what and what services they're going to provide. It's not a system, and we have to at least accept that as a given and figure out what we can do to change that, to move forward. And I think recognizing the problem and acknowledging the problem is the first step in that. So that's our real challenge, is we need to focus on systemic advocacy, both fixing broken systems and creating systems where systems should be but don't exist, right? So those are the two places. So on fixing broken systems, I have a couple of hopeful things. I won't be as depressing as Martha was. There are a couple of hopeful things. Court debt. Okay, the issue of court debt. I've been a legal aid lawyer, like I say, for 33 years. Municipal courts, traffic courts, nuisance violations, places where people kind of get ground up in this black box. To be quite honest, nobody was paying attention, all right? It was a system that did not have a right to a public defender, because in that system there's not a risk of jail time, and so except for some really innovative programs that look beyond, you know, sort of the classic court-appointed model, there really weren't public defenders in those systems. And most legal aid programs are going to do the housing case or a domestic violence case or something else, and traffic court, nuisance violations kind of get shuffled off to the side here. They're not a priority. They're not a high priority. But the thing is what we see from that is that in the absence of public service advocates, in the absence of lawyers paying attention, systems can run amok, okay? Lawyers, part of what lawyers do is hold systems accountable, and part of not having lawyers in systems means that that accountability is lost. How many people in this room have read the Department of Justice report on Ferguson, Missouri? Okay, a good number of you. For those of you who haven't, I recommend it. I recommend it highly because it talks about how the system fails, right? And part of the way the system fails is that it isn't regulated, or that there is no one paying attention to the macro outcomes of a particular system. And that's what happened in the Ferguson municipal courts. But guess what? The Department of Justice issued its Ferguson Report in March of 2015. We're now in, January of 2018. It hasn't even been 3 years. And there has been movement in more than 20 jurisdictions around the country to try and change the problem of court debt and the fact that, as the Ferguson Report reflects, that it has a disparate impact on people of color, and it really enforces a system of poverty criminalization,
And,
right?
and debtor's prison.
And debtor's prison. That's exactly what it is. And we run our courts on that. In some states, legal aid programs benefit from those court fees to be able to support their services, and we need to look at that. But what's incredible is that when the U.S. Department of Justice makes a finding and issues a report that basically says your court system is racist And that's more or less what the Ferguson Report does. Guess what? That has a difference. That provides a huge opportunity. It's not a surprise to, students of institutional racism that maybe courts might be, sort of solidifying past racially improper practices. But when you actually have the U.S. Department of Justice saying, this is wrong and it's illegal, you get traction. And part of the reason since March of 2015 that there's been so much progress in making advances on court-related debt, both legislatively and through litigation, is because the U.S. Department of Justice took that stance and made a strong statement that said, this is wrong and you need to do something about it. And so, one of the morals to that story is, guess what? Elections have consequences, and I'm not political either, but what the Department of Justice under Eric Holder does might be different than what the Department of Justice under Jeff Sessions does, and we can't forget that when we're talking about where our role as lawyers are and what we need to do as lawyers. So, I think that's a success story. We're making immense progress on court-related debt, and that's a core poverty law issue that isn't just about individual representation, which is critically important, but is about making systems better and fairer. The second place where we're looking at fixing systems is, how many people know about cash bail? Do you know what's happening in this country right now over cash bail? I never dreamt in my lifetime that we would be having a conversation about the elimination of cash bail. And that's happening in the United States right now. And from a poverty advocate's point of view, that's incredible. Do you know how hard it is to prepare for your criminal defense when you're in jail? And do you know all of the bad things that happen to you as a result of the fact that you're incarcerated while you're waiting to find out if you're going to be determined to be guilty or innocent? Your life is ruined if you're in jail during that period of time. And having a serious conversation in this country about the fact that maybe we should question whether there should be cash bail. Maybe we should look at whether cash bail disproportionately impacts people of color. Whether or not we should look at whether or not cash bail creates a system of of poverty imprisonment, debtor prisons. Because yes, people have been accused of committing an offense, but if you're rich or even middle class, you're not sitting in jail while you're waiting for your guilt or innocence to be determined. You're out preparing for your defense or preparing for whatever else is going to come after that. If you're poor, you're at Rikers. Okay, you're in the Cook County Jail. You're in some kind of hellish place where it's cold and improper and you're being treated not so great while you're waiting to determine whether or not you're guilty or innocent. And so the fact that we're actually having a serious conversation is incredible. You all are in a position to actually move that forward. Part of the question is, what's the alternative? What do we do differently? If we're not going to use cash bail, how do we figure out, what are the norms that are going to be used to decide who gets released and who doesn't get released? And you and social scientists and legal and social together are really in a position to move that forward. What are risk assessments? Can we really assess risk? What does it look like? How do we assess risk in a manner that doesn't institutionalize past racism? How do we figure out ways to create a system to decide whether or not people should be released pre-trial that don't require cash and that are fair and are sensitive to the fact that maybe past criminal contacts shouldn't be counted if you're in New York with stop and frisk, because guess what? The way that was implemented was a way that in fact was disproportionate to communities of color. But the fact that we're having this discussion, the fact that it's actually getting traction is incredible, and it's hopeful, and it's something we should all be positive about. In terms of creating systems, a couple of points that I want to make that really talk about law and technology, and I'll just a little bit about lawyers aren't really keen on technology writ large, right? Okay, maybe we use some technology tools, but in terms of technology being able to move the law forward, we're kind of generally anti rather than pro, and we need to really think about what that looks like. So one of the questions I have, why isn't there a universal legal aid application? right? Do you know how the system works right now? You go to some legal aid program, you talk to them for 10 minutes, you give them your information, they're like, oh, we really can't help you with that. You need to go to so-and-so down the road, and the 10 minutes and the data that you provided is lost, and then you're sent down the road to someplace else. And if you're in a big city, you can go to 3 or 4 or 5 or 7 different providers trying to figure out where to go. Well, listen. Why isn't there a universal legal aid application? It's a rhetorical question. I know all the reasons that you will give for why there isn't a universal legal aid application, but weren't those exactly the same reason that colleges had a decade or 15 years ago when there wasn't a universal college application? Oh, we have a different procedure. We need to ask this question. We want to ask the question this way, blah, 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 blah. There are 1,000 reasons why we can't do something, and what we need to do is create the mentality about how we can do something. And so how do we set up a system where people can apply for services and be matched to the largest number of available services that are there? I mean, the possibilities with technology today are really pretty, really pretty extraordinary, particularly in markets and cities where there may be multiple resources available to people, but not a clear way to get access to those resources. We could do a huge amount to moving that forward.
And Alex, I think you need to wrap up a little bit.
Really?
Yeah.
Already?
Yeah.
Oh, no way. No way.
That time just flies by.
Time flies. All right. So the point is like, think about when you wanted to go to dinner a decade ago on a Friday night at a really nice restaurant. Guess what? You were like, that took a lot of work, right? And now you have open table. Think about you needed to get a ride at the last minute to somewhere across town. That used to be a problem sometimes, and now you just touch your phone and Uber or Lyft shows up. And whether or not you love those new services or not, because of their employment practices or whatnot, think of the possibilities. Guess what? What's Uber or Lyft? It's a bunch of people who are willing to drive cars for money, who are willing to be matched with people who are willing to pay money to get driven in a car, right? Well, I know a lot of poverty lawyers that want to help people with legal problems, and I know a lot of poor people who have legal problems who are looking for a lawyer. And what we really need to do is to start thinking creatively about what is that? What's the Uber, or what's the Lyft, or what's the open table for access to justice? And we need to think about how we can actually match people with the available resources as quickly as we can.
Thank you, sir. Now, let's pause for just a moment. This would be a good time with those 3x5 cards in front of you. If you'd like to ask a question, please fill it out right now. We'll just pause literally just for a couple of moments. And then I would ask the students to come to the aisles, pass it to the middle, and Aaron and Terry will be there in the front to sort it out. So if you have such questions, this is the moment to write them down and send them to the middle. Boy, that's a pause. And if there are any, just kind of wave them so our volunteers can pick them up. With many thanks to the students in the city of San Diego, who you'll see them all around, and they are working for free to help us out. Okay? All right. Let us move on. Justice Goodwyn, I turn to you. Bernard, if you would.
Sure. The linchpin of our democracy is the rule of law. And as Americans, we believe ourselves to be a nation in which all are treated equally before the law. But as my colleagues have just said, we have to wonder whether or not that is still true today in our country. According to the Department of Justice several years ago, more than half of the people who qualify for civil legal aid have to be turned away because of lack of funding. And that doesn't even include the people who don't even know where to go to get any type of legal aid. And what we know intuitively has been proven empirically. Having a lawyer in a case makes a difference. And to the extent that poor people don't have lawyers when they go to court, they get different results than what everybody else gets. They get different justice than everybody else gets. As lawyers and as judges, we've always got to keep in mind that all those things that we hold so dear, those things that are said in our Constitution, the things that are written in statutes, they don't mean anything to a person who cannot validate those rights through the court process. And we've got lots of people who cannot do that. So I agree with everything that my colleagues have said. But the question is, where do we go from there? What do we do? And I know for me, something that I remember one of my coaches saying to me, when you're really getting pounded, what do? You start where you are, you take what you have, and you do what you can. And in Virginia, what we have done is create an Access to Justice Commission. And the commission is a collaborative entity that brings together the court, the bar, civil legal aid providers, and other stakeholders in an effort to remove barriers to civil legal justice. And honestly, there are a couple questions that really have to be asked in practically addressing these issues. One, we ask is, what is the barrier? I know Alex mentioned a number of things, Martha did also, and somebody has to sit in the room and decide, well, why can't we do that? And then the next question is, well, we don't have the money. Okay, well, we don't have any money, so we can't do that. What else can we do? And that's when innovation comes into play. You've got to think of things perhaps in a different paradigm. You've got to use what you have to make things better. And say, for instance, this organization, through our Access to Justice Commission, which includes these disparate individuals who are stakeholders, we can organize. We have a pro bono consortium where quarterly various pro bono providers and legal aid providers get together, and they're coming up with a database of what everybody's doing so they can coordinate their activities and they can do things more effectively, more efficiently, and they can help each other. Public attention to our problem. Well, why don't we seek a grant from the Virginia Legal Aid Foundation, Virginia Law Foundation, and partner with the public interest radio station and come up with radio broadcasts, public service announcements that's funded by the Virginia Legal Foundation that's heard throughout the state so that people understand there is a justice gap, so they understand there are civil legal needs that need to be met. So what we have to do, I really think, is just figure out what resources we have and apply those to the issues that come before us and do the best that we can to make things better, given where we are. I mean, we've got to be pragmatic and we've got to be practical. We've got to realize that there are a lot more resources perhaps at hand than we believe. For instance, with this justice gap that we have, one of the big things that needs to be done is to increase the amount of pro bono that attorneys can provide. So let's try to what are the barriers to that? Let's figure out what they are. Well, it's so hard, going down to the legal aid office, trying to find a case that fits my skills, matching people, things. Well, in Richmond, the Capital One, which is a Fortune 500 company, Central Virginia Legal Aid Society, McGraw Woods, a big law firm, and the Richmond Law Foundation got together, and a bunch of Capital One IT people came up with a computer program, Justice Server, which allows individuals or attorneys to receive messages concerning when legal aid has cases that fit their particular skill set. They don't have to go into the office. They can even get the file online. It makes it easier for them to volunteer. How about Ask a Lawyer, which we have in Virginia, which is an online service where individuals can send in questions online and lawyers can just check their mailbox and answer those questions at leisure when they get a chance. All those things help to improve our access to justice. What about increasing the pool of people who can do pro bono work? Well, the Virginia Supreme Court supervises the bar. So we can change the rules to make sure that emeritus members of the bar can provide pro bono services. We can change the rules of bar admission to make sure that in-house attorneys who are barred in another state can provide pro bono service, making the pool bigger, helping to make the access to justice question a little bit smaller. Now, having said that, there's so much that can be done and can be done on a practical basis. And the problem I find is that sometimes it just seems so overwhelming that the little bit that you do, you wonder if it's enough. But you can only do what you can do. And you have to always ask yourself, am I doing everything that I can do? And I really do think it takes mindfulness more than anything else. Being aware of how what we do affects access to justice. And in any instance that we can, figuring out a way how we can make it better. How we can change it, especially as a court, how we can change our rules, how we can change our policies, how we can change our procedures to improve access to justice. And that's what we've tried to do in Virginia. And I would say judges have to be leaders in improving access to justice because of our concern for the rule of law. We have to be enforcers. And I think that obligation goes to every single person who's raised their hand and taken an oath of office as a member of a court. I guess I'm not as pessimistic as people are, but I do think there's lots and lots of work that has to be done.
Thanks, Bern. I turn to you, Cara, if you would, please.
Sure. So I wish I could say to those of you in the audience who are thinking, well, this surely is not the state of affairs on the criminal side. I wish I could say it's not. Unfortunately, it is. So back to the depressing theme. Let me just give you some basic numbers, some of which you may be familiar with just from mainstream media accounts. The United States has more than 2 million adults and children behind bars. We lead the world in our rate of incarceration, and 4 out of 5 criminal defendants are poor. So if you just do back of the envelope math, you can tell that the need for indigent defense representation in criminal court is absolutely tremendous. Of course, since 1963, the Supreme Court has said that poor criminal defendants are entitled to effective representation. But as we all know, the mandate of Gideon remains aspirational more than 50 years after that decision. Countless reports by academics, including our own Paul Marcus, by organizations like NLADA, NACDL, ABA, report after report for the last 50 years has documented the gap between Gideon on paper and Gideon on the ground. Highlights of those reports are consistent, right? They paint a picture where across the country, public defenders are overworked, underpaid, lacking often in structural independence, and certainly lacking in support services like investigative and expert resources that are needed to really zealously represent criminal defendants. So it's not surprising that we see terminology like America has assembly line justice, or that someone like Brian Stevenson would say, quite rightly, that in the United States, our system of criminal justice treats you better if you are rich and guilty than innocent and poor. And he's right, and that's a moral stain on the United States. So I want to focus my comments actually in my time to talk a little bit about youth in the system, in the criminal justice system, particularly of importance today, I think, in part because that's been where my research focus has been lately, but also because I think too often those who aren't familiar with the criminal justice system think of a youth experiencing it as sort of a lower stakes scenario, and actually nothing could be further from the truth in this country today. So I want to say a little bit about that. So kids charged in adult criminal court are certainly entitled to counsel per Gideon, and since the Supreme Court's decision in 1967 in Ray Galt, youth in delinquency proceedings are also entitled to effective representation. But as with Gideon, there has been tremendous disconnect between the Galt right on paper and that right in practice. We've just completed, 2017 was the 50th anniversary year of the In Ray Galt decision. And on the anniversary of that decision, the National Juvenile Defender Center released a report concluding that nearly every state in the United States is falling short on its obligations under Galt, is failing to meet its obligations under GALT. And so what that looks like is that children are too often interrogated without counsel. In 43 states, youth are permitted to waive their right to an attorney before they've had a chance to meet with one and understand what it is they are waiving in the criminal process. They enter guilty pleas without counsel. And in 36 states, youth who are entitled to free lawyers per GALT are required to pay fines and fees associated with that representation. So there's a real gap, as I said, between the right accorded to young defendants in the system and that reality on the ground. At the same time, the stakes for youth in the system are tremendously high. Every jurisdiction in this country has some mechanism for transferring youth defendants out of juvenile court into the adult criminal court system, and most states have several mechanisms for doing that. Once a youthful defendant is in the adult criminal court system, that defendant is exposed to mandatory minimums that were drafted with adults in mind, that were not legislators thinking about youthful defendants. At the most extreme end of the sentencing spectrum, the United States is the only developed nation in the world that still subjects children to life without parole sentences. And while those are admittedly rare in the system overall, juvenile defendants are routinely exposed to life-altering sentences, if not death in custody sentences. At the same time, children in correctional facilities, whether they are juvenile facilities or adult jails, where juvenile defendants often sit, youth in those situations are, best case scenario, experiencing professional and educational setbacks. Worst case scenario, they're exposed to physical, sexual assault, solitary confinement, and significant risks of suicide. So the problems in the criminal justice system are really tremendous, and they're particularly pronounced for youth in the system. Hopefully we can talk during question and answer and maybe among ourselves about the impact of the recent, of the Trump administration, and I will be political and put that out there and say that, because there has been tremendous effort over the last 5 decades since Gideon, among academics and policymakers and NGOs and nonprofit agencies to try to aggressively implement that right. And it's been an uphill battle. However, what we are now confronting are a number of things. First of all, we're dealing with law and order rhetoric and fear-mongering, even in the face of historically low crime rates. We're dealing with resistance, if not outright opposition, to fact and science at a time when what we need in the corrections space is data-driven research, and when it comes to kids, brain science to inform our sentencing practices. And we're also dealing with, at the federal level, with charging and sentencing decisions that are absolutely out of step with not just blue state experiences, but really decarceration success stories that have happened in a number of really historically tough on crime states. So all of that is to say, and I'm sorry that this is a depressing narrative, but all of this is to say that however bad the Gideon Galt story has been for the last 5 decades, it's gotten worse, I think, in the last year. And I think we're facing a real risk of backsliding in 2018. Okay, so Paul asked us to talk about what we can do to improve the situation. So I promise I will do that, and I'm going to turn to doing that. And I want to say, Justice Goodwyn, that I really like that quote from your coach of start where you are, take what you have, and do what you can. And in some ways, my approach to thinking about these issues in terms of reform today uses that philosophy. So I'm going to remember that coach's quote. So where are we? Use what we can. So of course, I think the first front has to be doubling down on what those of us interested in Gideon's promise have been doing for the last 5 decades. And I think of those reform efforts as really happening in 3 spaces: education, litigation, and legislation. So we've talked a little bit about education on this panel so far. I think that's absolutely true. Most criminal justice reform success stories have happened in the wake of exposure, if you will, right? The kind of work that the Sixth Amendment Center is doing, that Measures for Justice is doing, where you are giving lawmakers facts to anchor their lobbying and decision-making with, and you're also giving stories, as Martha mentioned, you're giving stories to the public that really help move the needle, that help change public sentiment and perception. So we need to continue on that education front. On the litigation front, I have always maintained that there is a place for systemic litigation. And by that I mean litigation designed to challenge systems, not just systems that occasionally have Gideon problems, but systems that are so fundamentally broken that those systems are regularly violating the constitutional rights of their clients. And those kinds of lawsuits are time consuming, they're expensive, they're difficult to enforce even when you win a great remedy. But if you look at a state like New York, where they had nearly a decade of litigation, that resulted in the state saying, yeah, actually counties can't afford to pay for criminal defense, so we will pick up the tab. I think it's
And that's really just this year.
right, 2015,
Yeah.
right, on the eve of that lawsuit, yeah. So, so yes, that's a recent example of the fact that in the worst case scenarios, there is a place for that kind of litigation, notwithstanding its drawbacks. And on the legislation front, I think there continues to be a place for discrete legislation. Senator Booker introduced Equal Justice Under Law Act, creating a federal cause of action that permits defendants to seek prospective relief. Right? Too often, defendants are told, oh, well, you have post-conviction relief. You have a direct appeal. That is not useful, right? When you are a criminal defendant who is presented with ineffective assistance or the constructive absence of counsel, being told to seek a remedy after the fact is in fact itself a constitutional violation. So legislation that can give folks a ticket to court on a prospective basis, I think is really useful. Okay, so those are things we can do to double down on enforcing the right to counsel. I want to pivot back to the juvenile space, and there are analogs in the adult space, but I want to talk a little bit about the fact that even as we're doubling down on right to counsel enforcement, I think it's really important that we recognize and be pragmatic and say, look, we've been at this for 5 decades, and the reports are pretty consistent as they come out each decade, and we're also in a new political reality. And so I think what we can do at the same time as doubling down on these enforcement issues is start to temper the harshness of our criminal justice system outside of Gideon and Galt in a way that is nonetheless complementary. So what do I mean by that? In the juvenile context, this is what I think that looks like. It looks like getting extreme sentences off the books as they apply to children and making it harder for states to impose those sentences where they do exist. So how do we do that? In the juvenile space, in recent years, as many of you may know, the Supreme Court has significantly limited the extent to which states can impose juvenile life without parole. It has held that children are different in the eyes of the law and that state sentencing practices must reflect that fact. So I think even as we are working in a parallel way to enforce Galt, we can be working to leverage that trilogy of cases, the Miller trilogy, to achieve a number of goals for kids. The first of which is banning juvenile life without parole. There has been yet another recent request for the court to reconsider that. I'm not sure the court will think it needs to reconsider that because there has been such tremendous movement in just the last 5 years on moving toward the abolition of juvenile life without parole at the state level. So that's going to happen. That's within reach and it's on the horizon. I think it's important to leverage that Miller trilogy to return to a default where juveniles are handled in juvenile court. Right? There was a time when it was difficult and rare for a child's case to be dealt with in adult criminal court, and I think we can and should move toward leveraging that trilogy of cases so that we return to that default. I think that we should require states to employ procedural safeguards when and if they expose kids to death in custody sentences that are comparable to what adults enjoy when they face a death sentence. Right? The court has said juvenile life without parole or death in custody sentences are tantamount to a death sentence for kids. And so if that's true, then states should be held accountable and should be required to provide the kind of procedural safeguards. I think of that as sort of Wiggins for kids. And last but not least, and again, I think this is doable, we need states to invest in meaningful back-end relief for juvenile defendants who may have been convicted of a serious crime, but who have paid their debt to society. And we see that in states like California, but also in states like Pennsylvania. Pennsylvania houses the largest population of juvenile lifers in the country. And in the last year or so, they have actually released through a parole process close to 100 individuals. So that I think is a possible achievable goal. And in these ways, we can continue to enforce the promise of Gideon and of Galt, but at the same time pursue complementary reform measures that I think temper the harshest consequences of what is our current reality.
Thank you so much. We have a lot of very good questions with thanks again to Aaron and Terry. Do we have some more still? They keep coming. And generally, I'm going to just open this up to the panel, whoever wants to jump in, and we'll kind of bounce around there. Here's the first one. Most of our arguments involve appeals to progressive values. Is it really the case that access to justice is inconsistent with conservative values? If not, why are we not making appeal to these values? Martha, why don't I start with you, and then we'll kind of go around.
I couldn't agree more. And the conservative values, rule of law, stability, legitimacy of the legal system. Justice talked about that. I think that is about as conservative as you can get. I also think, and it's connected to the arguments that Cara was just describing about criminal law, that the bipartisan commitment to criminal justice reform remains strong in this country. And the current movement has to be state and local, because there's no chance at the federal level. But state and local is where most criminal law is.
90%.
And 90%. And there is, leading the way is Texas. And this is a conservative movement. This is a movement that reflects, again, cost-benefit analysis and also evangelical conceptions about forgiveness. I think that there are enormous resources that are very much in the variety of conservative communities that are relevant to criminal justice and also to civil justice. I do think that helping people identify what the costs are, the financial costs and the moral costs of our current crisis, that is absolutely conservative values, I think, right at their heartland. And then, and just one more thing, some people would identify the business community as conservative. I think that's probably not true. I think the business community is as diverse as everywhere else, but let's just assume that it is. The business community can be tremendous allies here. In New Hampshire, the business community had been leaders in civil justice funding. Why? Because, and I've talked with people there, they say these are our consumers, these are our employees. It affects whether or not employees can come to work. If there is a child who is facing disciplinary action in school and it gets tied up, it affects whether or not there's a consumer who can actually buy a product if they actually have lost their Social Security benefits. So I think that connecting those dots has led to some business leaders being very committed here, and that includes providing in-kind services like tech advice. And so I don't think there's any shortage of conservative values to which we could appeal.
Bernard, let me turn to you in terms of the experience in Virginia. Is that your sense as well? Do you agree with Martha?
Oh, no doubt about it. That the whole idea of access to justice, I think, should be expressed in terms of fairness. And when you do that, who's against fairness in the legal system? Nobody's against that. Everybody wants that. The biggest problem is education. People don't know. Individuals are absolutely astounded to know that most poor people can't get a lawyer. They think that there's a civil Gideon. They really do, because they've just never been faced with the problem.
And of course, they see it on television.
Exactly.
There's the lawyer who's standing up.
And that was one of the things that led to the public service announcements that we did
Right.
in Virginia, to try to just educate the public on the issue that is access to justice. They don't understand it.
Yeah, Cara, you wanted to jump in as well.
Yeah, I wanted to just say, I mean, certainly on the criminal side, conservatives in the last 2 decades have led the criminal justice
Yeah,
reform
Texas is, of
movement.
course, a
Texas,
prime example.
Tennessee, Louisiana, and not just individual states, but organizations like Right on Crime and politicians who are admittedly conservative.
Koch brothers.
The Koch brothers. My hesitation about the conservative approach to criminal justice reform is that much of it followed in the wake of the 2008 recession and was driven by the kind of cost-benefit analysis Martha was referring to. And in my mind, while that is, there is part of my mind that says, whatever brings you to the table is great, that works. What troubles me, though, is that when times improve financially, those individuals might just as be happy to build more prisons once again. And what troubles me about a cost-benefit driven discussion, which is often what we hear in conservative circles, is that it overlooks the racial and economic inequalities that are perpetuated by these gaps between Gideon in practice and in right. So that would be, my word of caution to just fully embracing the conservative approach to criminal justice reform.
Alex, your take on this?
I was just going to say that clearly in cash bail and in the court debt, there have been really balanced coalitions of folks working on those, because people get, if you lose your driver's license, if we want you to be a productive member of society and you lose your driver's license because you owe a fine or a fee, that doesn't actually serve anyone's interests.
And that's true at the local level as well as state.
Yeah, exactly. And the most of the legislative gains have come in pretty mixed states with pretty broad-based coalitions of right-left people who have been supporting those changes.
Here's a very different question. How far would you be willing to go in breaking down the profession's monopoly on the providing of legal services? Creating instead of spectrum, does this resonate just a bit, does it? Creating instead a spectrum of law-related services that can be provided at a much lower cost.
Not only do we need to talk about it, it's already happening.
Yeah, you bet.
In a big way. And so this should be, I think, embraced. We should have the notion both of allied legal professionals that the medical profession has done for a long, long time, and also on the tech side, if we don't do it, we will be made irrelevant. So I actually, as dean, had to field, of course, regular complaints, and one of the ones I will never forget was someone objecting to the immigration law app that they assumed came from Harvard Law School. Well, it didn't, and it was filled with misinformation. I tracked it down to the innovation lab and to business school students. And when I said, you might have wanted to talk to some lawyers about this, their answer was, well, if you're not going to do it, we're going to do it. And that, for me, was a wake-up call. And that's why I'm so delighted to be one of the advisors to the ABA Center on Legal Innovation, which is doing, I think, very interesting work, promoting the development of apps and other kinds of technology. I see Andy down there. Thank you for your leadership. And also, Legal Services Corporation has been giving out technology innovation grants now for 10 years, developing statewide interactive websites. The Microsoft Corporation has built a partnership to create state-level portals that allow anyone to get access to information. The Maine Pine Tree Legal Assistance has developed an interactive website called Stateside for people to understand veterans benefits and get tailored information. Look at, eBay resolved more disputes than many states last year with online dispute resolution algorithmically, no human beings involved. It's already happening. So we need to actually acknowledge the reality, and if we want to be part of the revolution, join in, rather than saying, oh no, unauthorized practice of law.
Let me just pause for a second. There's some folks standing in the back. There are some seats in the front, so feel free to come forward if you'd like. Alex, you wanted to jump in.
So yeah, I feel very strongly about this. Like the train is like racing out of the station, and we're like saying, oh, no, 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 and we're going to be left behind, right? If we want to have a say in what the new there's going to be a new justice system in our country, just like taxis are a thing of the past, okay? There's going to be something different, and if we don't start putting ourselves forward, it will happen without us, and it will be worse for it, okay? It is happening without us, and it ends up getting done poorly because people don't want to deal with lawyers because lawyers throw up all the barriers to why this can't be done, all the potential pitfalls for why this shouldn't be done, rather than trying to figure out how it can be done. We're not do it, we're the conservative, we talk about conservative values. That's what lawyers are at base, is like the status quo, stare decisis. We want it to stay the way it always was. It's not going to stay the way it always was. And if we don't actually take control of that process, it will be done to us rather than with us. And that would, if people take anything away from this today, I hope that that's what you take back to your law schools, because that's what we need to be talking about. We need to be talking about access to data. We need to get courts, and tribunals.
I'm going to go to the courts in just a minute.
We need to get courts and tribunals to actually start collecting real data and making it publicly available so we can actually look at what's happening and make evidence-based decisions about where we should go.
Now, I'm going to turn in a couple moments to see if this translates into the criminal justice system. But are the two of you, to a certain extent, indicting us? That we're not doing this in legal education and that we should? Can we? And how do you do that?
There's leadership in legal education. The Georgetown, Suffolk, Chicago, Kent have clinics developing really cutting-edge uses of technology to promote access to justice. I think that there needs to be more attention. I think that there could be more sharing of some of these best practices. And there are also courts that are at the cutting edge. There are courts that have kiosks. There are courts that actually revolutionarily have developed statewide forms that are uniform, that can actually then have online.
Radical.
Yeah, radical, but then can have online services that match what people expect when they go to Amazon. They want to get the same thing that when they go to the courts. And it's happening, and there are law schools that are playing very important roles. I don't think that's been mainstreamed so that you can't graduate from law school without understanding that this is the revolution and we all need to take part in it. And I don't think it's been actually drawing on the rest of the resources of universities. You think about every university or college that has an engineering school, that has a computer science program, they are looking for problems for students to solve. I think they could partner with local courts. We've tried to do that in Massachusetts. Same thing with statistical analysis and empirical study.
Well, okay, I understand it on the civil side. I see how it fits. Bernard and Cara, on the criminal side, would this work? To have others involved and new technologies? Or is it working?
I couldn't tell you. I can't even fathom how a non-lawyer is going to help a guy who's sitting in jail. I don't. So.
And the Sixth Amendment requires the right to counsel.
Right. So I don't.
Yeah, so I understand the appeal of this, and I've heard this.
It does.
Yeah, absolutely. And I've heard this proposal at a number of access to justice conferences. I'll tell you why I don't like it. I think that states should be forced to internalize the costs of their charging and corrections practices. And my fear is that if suddenly they don't have to actually fulfill the promise of Gideon, but they can get away with having a friend or a coach or a pastor be the person standing next to you when you're charged, then why wouldn't they do that, right? It's giving them a pass. And part of what I think we need to do as lawyers is say, look, if you want to have 2 million people behind bars, you got to pay for that. And what that looks like is providing a lawyer for each and every one of those individuals.
Well, let me,
Can I
sure, Alex.
Yeah.
I'm just saying, I agree, but I disagree at a fundamental level in that there are 1,000 things that lawyers do that lawyers don't need to do right now, right? Being in court with somebody, that's what lawyers should be doing. But could we make criminal discovery different such that it was easier and quicker for those lawyers, so those lawyers had more time to actually be standing with people in court and not fighting over whether they should get access to information? Could we streamline a system where, in fact, people get access to information immediately and they're provided access to that information?
Sure, but that's a different point.
Exactly.
That's a point that says, well, that public defenders need better investigative and mitigation experts, and that they need data collection services. And that's all true. But that's a different
Bernard,
point.
I take it that's consistent with your concern as well.
Exactly.
Right, but the point is technology can help us with that.
I agree. Oh, yeah.
And part of what happens, I think, with lawyers and with the monopoly is that we're so concerned about that the lawyers will be taken out of the courtroom at the point where I agree with you, they're critical, that we're not willing to have I don't want like non-trained legal techs going to court with people in civil cases. What I want is to use technology to the highest degree we can to reduce so that the limited resources, precious resources, human resources that we have to go to court with people are focused on the people who need them the most and at the times that they're needed the most. And technology could make us go a long way toward that, and because of the risk or fear that lawyers will be replaced by an algorithm, we don't have the conversations in the way I think we need to. And that's really all I'm encouraging, is that we don't let the fear of justice by algorithm replace a real conversation about how many things in our monopoly should actually be passed on to history, and rather than continue to be institutionalized.
So I'm going to agree and disagree with you, because I think that there are already uses of algorithms in the criminal justice system, okay? So the risk assessment tool that is spreading like wildfire across the country, that's determining who's going to get what level of bail, who's going to be eligible for what kind of parole, is using artificial intelligence, algorithms that are not transparent, that are not comprehensible to lawyers, much less to anyone else. So the non-lawyers are already in the business. And so, again, I think we're missing the boat if we say, can lawyers be involved? They are involved. And on that issue, that particular one, the risk of amplifying rather than reducing racial bias is so enormous, because what the algorithms do is they simply take in data about past practice, which, guess what, is racially biased, and then infer from it patterns. So I think that this is a crisis that is not going to get public attention because it's so complex to talk about algorithms, and yet it is already transforming our criminal justice system. So there, I guess I think we should just, again, on the criminal side as on the civil side, saying it's happening, lawyers need to be at the table, and we need to be actually participating in the discussion.
In charge. We need to be in charge.
Well, and then I'd also say, maybe this is just too pie in the sky. Our criminal justice system is such a travesty that we shouldn't be talking about tinkering around the margins. I think that to talk about life without parole assessments for juveniles, where the suicide rate is so extraordinary, even when there's suicide watch and no one's allowed to commit suicide. I mean, it is the biggest scandal in this country. We are the most incarcerated state in the history of the planet, and we are destroying communities day by day. So right to counsel, great, but when 98% of the cases are pled out, I mean, we're tinkering not even on the Titanic. On juvenile justice, I guess I'd put to you, Cara, what do you think about lessons possibly we could learn in the treatment of child soldiers around the world, where there are even people who no one denies have participated in mass violent activity. They are not subject to criminal sanction. They may be actually introduced to Truth and Reconciliation Commissions, where they're given a chance to tell their story and participate in rehabilitation. I mean, don't we need a different paradigm altogether?
Is that a question for me? Paul, is that allowed? Is she allowed to do that? And am I allowed to answer?
My gosh, she's a former dean of Harvard Law School. Of course she's allowed.
Yes. So I'll just say quickly, of course I think we need a new paradigm. Of course I would love to say let's blow up the system. But I will tell you, it's disheartening to me. I've just finished doing a book tour. I had a book come out recently called The War on Kids, talking about the plight of juveniles in the system. And I cannot tell you how many times during radio and speaking engagements I was met with not, shouldn't we be blowing up the system, this is a travesty, but adult crime, adult time. I mean, that is a recurring theme. So really, I guess it brings us back to the question you added to Paul's list of questions, which is why can't people wrap their arms around the structural problems, the constitutional flaws, the neuroscience that tells us what it does? Well, why can't they?
Yeah.
Well, let me shift gears, although I think related here, into a point, Bernard, that you made a little while ago. Again, question from the audience. Any tips for motivating lawyers and law firms to support access programs. And we've seen some with incubator programs, which one of you may wish to explain, legal aid, et cetera. Even if they're not willing to provide significant pro bono services. Are the practicing lawyers sufficiently involved, financially and otherwise? You made some reference to it, Bernard, earlier in your statement.
That is something that needs to be improved in Virginia. And it's interesting, there are certain communities where there is a culture of pro bono activity, say like around Richmond, see out in some place like Harrisonburg, out in the far west, where they are Charlottesville, where they have a legal culture where you're expected to provide pro bono service and to support legal aid. And you've got others like Tidewater, which is where I'm from, with the southeastern part of the state, where it's just not really part of the culture that people are very concerned about providing pro bono services.
Yeah, Alex, did you see it in practice? Were there partnerships at the local level?
I think tons. There are law firms, again, they vary, from place to place and just from partner to partner, but law firms are providing incredible amounts of free legal services to low-income people, both at the macro level and just in individual cases. In California, when the travel ban came out, when there are disasters, there are huge influxes of resources and energy. And then just on a day-to-day basis, my experience has always been, if we had a big case and we wanted a law firm to partner with us on that and put resources into it, we could find one every single time, right? No matter how political the case was, no matter what it was, if we wanted a law firm to partner with us and provide not just be there in name, but to provide partner level support to make sure that there was actually a team of people staffing a case, we could get it every single time. And, and it's easier in a big city where it's all easy. Part of what I think our challenge is to try and figure out, how do we use technology and other things to be able to help, people in San Francisco help people on the Navajo Nation, or, there really is a rural urban divide in the quality of access to legal services and to access to justice, and figuring out a way to use technology to try and help, sort of bridge that divide would really be a step forward.
Yeah, Martha?
I just want to underscore this point about the rural communities, and technology can be a solution, and most people, even poor people, have access to a cell phone, but then it turns out access to justice involves minutes on the cell plan. And making sure that they're not put on call waiting or
so it really is
whatever.
That basic.
It's really that basic. I think partnerships with public libraries are incredibly promising, because there are public libraries in almost every community, and helping to train librarians. And there are even the lawyers in small communities may be willing to partner with the library, where they're not the only one who's at the front line. The ABA and Legal Services Corporation both have developed a toolkit about pro bono and promoting pro bono. I do think that law students have power here. If law students ask, what are the pro bono opportunities at this firm, that makes the firms compete, and that really does change behavior. I would caution, and Alex, tell me if I'm wrong, there's not a lot of glamour in the day-to-day poverty law. So you can find pro bono help for the test case that's going up on appeal.
Right.
But the day-to-day work, that's really much more difficult. And Skadden is an interesting firm that actually has partnered with legal aid organizations to create day-to-day services in domestic violence, in housing. And I think that to create an arms race like that, to have the big firms compete over the promoting of day-to-day services rather than the fancy test case, that would be a goal for me.
Well, Carl, let me turn back to you. If the glamour issue is significant in the civil area, boy, is that significant in the criminal area. Not too difficult to find a law firm on the big systemic litigation involving criminal justice or the death penalty case. But are you seeing the actions of the law firms involving day-to-day, routine kinds of criminal cases?
I don't know that it's, I mean, certainly yes, right? So in some cases, law firms, and of course there's variety, but are involved in post-conviction reviews, that sort of thing. Habeas tends to be particularly complex, so that's something where a law firm can provide, important resources. I do think, though, that sometimes the less glamorous issues, I mean, the Campaign for the Fair Sentencing of Youth, for example, that is moving to abolish juvenile life without parole, immediately after the court's decision in Miller was found retroactive, and thereafter the clock started ticking in terms of those 2,500 some odd individuals across the country having very limited time during which they could seek a resentencing. The Campaign for the Fair Sentencing of Youth was able to put together basically an army of pro bono attorneys that was willing to go out and find those 2,500 individuals and figure out where they are, what relief they need, and how to get them that relief. So I think that lawyers certainly can step up. One thing that I think would be great is to see law firms be willing to fund individuals, and it, I think, could be win-win. Fund individuals who are willing to go be a public defender for a couple of years, get tons of great experience, and if the law firm would be willing to pay them even a little bit more than what the public defender's office can pay them, it would be that much more attractive to the student, the graduate, and then that graduate comes into the law firm with some actual experience, which those law firms really want them to have in this day and age.
Yeah.
Well, and just on that one, a great example, David Stern, I think, blew us off this morning. He's not here. David Stern is with Equal Justice Works. He's at the conference, but he had better things to do this morning. So I'm taking his name in vain. But in any event, David's program sponsors, fellows
Terrific program.
to be in legal aid programs. But, one of the beauties of that is that firm then oftentimes gets engaged. So they have partnerships now where they have a law firm, oftentimes with a corporate sponsor, Intel, somebody like that.
Yeah.
They put, to jointly put up the money together to then fund a fellow that's at a legal aid program. The beauty of that
And
is
several law schools have partnered in that as well.
exactly, they have. And the beauty of it, though, is that is a way, like, people then feel attached to that fellow, and then, so, like, we had a fellow that was doing healthcare access, and so we had a situation where there could have been a big case, but we couldn't actually make sure, we didn't even know whether there was a big case until we had more data, and that meant doing more of these individual administrative hearings, and we were able to mobilize a whole group of people from this law firm to come in and basically help do these administrative hearings for refugee children who were having their healthcare denied, so that we could figure out the parameters of the problem and actually construct, if you will, a piece of impact litigation that then was able to try to correct the system.
Can I just slip in the word partnership here? Because I think another incentive for law firms is where they can be participating with some of their clients to support some of these innovations, because then the junior partners get a chance to meet with the clients and they can all be problem solving. And I've heard this and I've seen it in action, and I have an example, so story time. We actually, at Harvard, we created a fellowship in memory of my great and wonderful colleague, David Grossman, who passed away way too early. And last year, the fellow, funded in part by companies and by law firms, was able to partner with a bankruptcy firm to be able to save a low-income housing project that otherwise was going to be sold for market rate. And the bankruptcy lawyers came up with this great approach, which was to calculate the value of the housing court violations and to throw that into the purchase price if the seller would and the court would waive all of those, and therefore it came out as the top bidder. And so this one fellow, 1 year out of law school, saved 200 people in their low-income housing, and they negotiated a deal where there will be no rent changes for 50 years. I mean, this is pretty good. So the bang for the buck for these kinds of fellowships is then a point of pride for those who funded them. And again, creating competition among the firms and the corporations around those things, that's a good thing.
And again, I would emphasize, excuse me, the role of law schools here. I've been visiting during the time as an officer schools across the country, big schools, small schools, urban, rural, and there's a lot of activity going on, putting law firms together with law schools and students and clients, and there's a real opportunity, I think, for us.
I agree.
Well, let me shift gears now dramatically, and here's another question for the audience. I'm not hearing anybody talking about ADR. What about the use of mediation in particular to gain access to justice and promote self-empowerment? Are we not talking about ADR?
I have that on my sheet here. ADR, question mark. So
you didn't write this one, did you?
No,
Martha?
I didn't.
Just checking.
On the civil side, ADR can be a solution, but it can also be tremendously troubling. So if it's Mediation in a domestic violence context, I think that we all understand there are serious issues, but there's similar power imbalances in other contexts. The Supreme Court's campaign to make sure that mandatory arbitration is used across all kinds of consumer matters, that's disempowering and actually undoing state-level consumer protection laws. So ADR can be an enemy, even at the same time, in some cases, it can offer access. One problem is that if you have a lawyer on one side and not on the other side, mediation it can be as problematically unbalanced as litigation can be. So, you know, pluses and minuses, certainly it's a part of the picture, but it's a frenemy, I think is the word.
Bernard, on the criminal side, are things like the drug courts the equivalent of this, where it's not the kind of litigation we normally see in the criminal justice system?
Well, it's different in that it's similar to it in the fact that it's different. It's a different paradigm. But to me, it's not like ADR at all. It's more the court taking a more paternalistic role as far as being concerned about a particular defendant.
And that is across the country.
Yeah.
These
Oh, it's a great
alternative courts.
program.
Yeah. Others want to in on this, or should we move on? Alex, Cara?
Well, the cynic in me thinks we have alternative dispute resolution in the criminal justice system, and it's called pleas, right? The model was meant to be.
The 90 to 95%.
Yeah. But I do think that there are, you know, on a more serious note, I think there are models like restorative justice where, and when it works well, it brings together.
Can be great.
Yeah, you want to explain a little bit? That's a term I'm not sure everyone understands.
Sure, just the idea being that instead of exacting a punishment from a criminal defendant, that the system is seeking to repair and rehabilitate both the victim and the defendant in that situation. So I've seen it with both at the front end of a system where there's maybe, if it's a property crime, maybe there's an attempt to have the defendant make restitution and seek some kind of rehabilitative services. And on the more extreme end of the system, I've seen people who are serving life sentences, who engage and participate in programs where obviously the victims and victims' family members have to be consenting and willing partners, but they engage in programs where there is communication and outreach to try to heal wounds that have been caused by the trauma of crime.
Alex, at the local level, is this going on?
I think much of family law could be done in a very different way if we really put our minds to trying to figure out how to do that.
So what do you have in mind there? I'm not sure.
Well, I'm not sure any custody dispute should get resolved by evidence and judges, right? I'm just not sure. I'm not sure that that actually makes sense, and that looking.
He's a judge.
I just think we need. I just think we need to be way more radical about actually questioning the norms that we've created and thinking about whether or not there are better ways to do it. We're never going to have the Uber for law or for access to justice if we're not willing to like question all the norms. Like, should any family disputes be going to judges, right? Should evidence be a word used in relation with custody? Is there a different way to determine custody that doesn't involve evidence and that actually involves, reconciliation to the degree that that's appropriate and understands that there's a lot of domestic violence, and how do we balance, that, sort of that dynamic in a way? But I'm not sure courts do it any better than social workers could do it or someone else could do it.
And having practiced family law, I can only say for some families, only the gavel is going to actually stop the fighting. But I do agree to you to the extent that states that have adopted mandatory joint custody have changed the discussion. So the discussion is now, well, what's the visitation schedule? What's the actual parenting schedule? I think awarding any housing to the child is a good answer. And then the parents have to work out who gets to be with the child, but that's for another day.
All right, this is one we can get our teeth into. Following up on the earlier question of why it's so difficult to get traction on the access issue, to what extent is the difficulty due to the widespread belief in our country that poverty is due to personal failings combined with extreme individualism and the bootstrap principle? How do we overcome this? Also, are you discounting the role that race plays in negative attitudes towards such programs? Wow.
Yeah.
Who wants to jump first? Okay, on that happy note, Cara, I'll start with you. How about we just go around like
Sure.
this?
Okay,
I
so
suspect we have some different takes on that here.
this is what my students would say. Could you repeat the question?
I'm with you. And as Cara and I have talked about, that's why I don't allow them to use computers in the classroom, because that's what they always ask.
So,
Do you want me to
sure.
read it?
No.
Okay.
I was joking. Although it was lengthy, points for length. So I would say a couple things in response to that, maybe just to get us started. So maybe we are discounting the role of race, or at least we haven't given proper airtime to that piece. I think that's a fair part of that question. And there is racism baked into the system, right? I mean, I think in 2018 that goes without saying. In my space, for example, in the juvenile context, we have seen juvenile incarceration rates declining overall for the last 25 years.
Pretty dramatically.
Pretty dramatically.
Yeah.
However, children of color are not benefiting from that trend. So today, black youth are 5 times as likely to be incarcerated as white youth, and not because they commit crimes at higher rates than white youth. So there is racism in the system, right? And we know that that's a function of policing practices and where police, you want to talk about algorithms, hotspot policing, and where they decide to focus their resources are in communities of color and in impoverished communities. It's also because of implicit bias. You know, what a white child in the classroom does might be labeled as class clown, and a black child or a Latino child does the exact same thing, and they're labeled as disruptive and troublemaking and in need of calling the school resource officer. So we know there is racism in the system. All of what I just said certainly applies with equal, if not greater, force in the adult system as well. And as to the question of whether we blame people for poverty or expect them to solve that on their own, I mean, that's obviously a huge question. I think the short answer is yes, I think we do.
I think all those things are baked into the system. There's no doubt there's racism. There's no doubt that people default to stereotypes. And I think that the answer to that in many instances is to have stories, to have individuals, to put faces on the particular individual in a particular instance, and to indicate, honestly, it goes back to fairness. I really do think most Americans have a sense of fairness, and if you can appeal to that in any instance, I think they'll respond to it.
Martha?
So I agree with everything that's been said so far on this subject. I guess I would say this is why law matters, because actually, when we're talking about Social Security benefits, veterans benefits, special education benefits, these are not matters of charity. These are rights. It doesn't matter whether or not people think, well, it's their fault that they have these needs. It doesn't matter. These are their rights. And that's why enforcing the rights is so central. And with even more force, I'd make the point about race discrimination. It doesn't matter what people think. This is what the law says. This is what's required. And if the law does not require it, it ought to. And we need to figure out how to enforce it. I think that the disaster of 2008 has made more people realize that they could themselves be vulnerable financially. And I think that the language of disaster, actually turns out to be somewhat helpful in terms of communication. And the same way that suddenly there's sympathy, at least for Texas and Florida, if not for Puerto Rico. Now there's a scandal. I think that to talk about disasters and is a way to actually say this is not about who's to blame. This is act of God kind of things. And we're in it together. I go back to the question about what about conservative values. I think that for every conservative community or religious community that says it's your own responsibility, I think that liberal and left communities have to actually say, yes, it is, but it's also community. And speak in the language that's multivocal, that can speak across these divisions. In every religious and conservative community, there is a community language as well. And it is we're all implicated in each other's futures, and we need to be bilingual in that way.
Alex?
I'll just say we live at a point in time in history where race and class are everything, and unless we actually think about race and class with everything we're looking at, we're not going to make good judgments. And the reason that we have the divides we have is because we really have lost senses of community. And we don't really have real community the way we have. We've bred an independence and a sort of personal, a sense of personal entitlement that we need to work beyond. And that's not a legal issue, that's a community issue, but that's really where I think we are. We really need to actually look at a community as a community and say, this is all of us, and how do we actually meet all of our needs better? And we don't do that because of the divisions of race and class, and that's our biggest challenge, is to actually to bridge those gaps.
We have time for but one more question. The time has absolutely zipped by, hasn't it? And this really is directed to any of you who wish to get in, and I think it will resonate with all of us here in the audience. Are we preparing future attorneys to be social justice advocates? Are we teaching them of the problems that we've discussed here today? Are we?
I think the
Well,
teacher
I'll
would answer that.
I'll start because I'm not a teacher, and so, I jump in where I don't belong. I will simply say, being somebody who hires lots of social justice lawyers, I'm amazed at the quality of people coming out of law schools who are...
You heard it here first.
Who went to law school to become public interest lawyers and actually were allowed to do that, right? Like, when I went to law school, that wasn't even a thing, right? It's just like you kind of happened upon it and you realized that was a good match for me. And there's like a whole industry of it, and you should be congratulated for that. That there really are people who go to law school to become public service lawyers. They track to some law schools more than others because some law schools are better, and you should up your game if you're not one of them. I think it's pretty heartening from a person who hires social justice lawyers. The pools are pretty incredible because there are a lot of really great, energized, and educated people coming out who want to do good.
Well, you're seeing a lot of smiles out there on that one. Bernard, are you seeing it with the attorneys that are coming out now?
I do. I mean, the millennials are a different breed. Their whole mindset is completely different than the mindset that my friends had when we were in law school. And it does trend toward being very concerned about others in general, about society, about making the world a better place. It's very positive. I have to say, I don't know whether the law schools are producing that or it's just an inherent part of the way they were raised.
It's the law schools. Lest there be any doubt.
Well, you guys are doing a great job.
Let me finish with our two legal educators, Cara and Martha. Are we doing enough?
I'm sure we could be doing more, but I have to say, when I come to conferences like this and other conferences where we have an opportunity to share pedagogical techniques, what we're doing in the classroom, I take a lot of comfort in hearing from my colleagues that, I know when I start criminal law, day one, it is not about mens rea or actus reus, it's about what the slides show, and that we have 2 million people incarcerated in this country and where that puts us in the international perspective. And I know I'm not alone in that, in trying to inject some realism and some call to action into the classroom.
Yeah, Martha, the final word is yours.
Oh, great. I hope you'll give a final word too. And again, thank you for organizing this conference and this panel. I think that there are two ways to understand the word prepare in that question. One is the official and unofficial curriculum preparing people? And I think we could do more, and particularly the themes that we talked about here today that include other disciplines and technology and thinking systemically, not just in terms of individual cases. But I think that the second way to understand the word prepare is, have we set up a circumstance so that people who want to pursue these kinds of careers are allowed to? And on there, we're failing drastically because of student debt, because of the lack of jobs, because of the career trajectory issues, because I can't guarantee that there'll be legal services corporation funding, et cetera, et cetera. So on that, I think it's not just the law schools, but it's larger society's problem, and it's on all of us to actually make that a priority going forward.
Quite some discussion. Please join me in thanking our panelists.